Hello everybody, welcome to JURIScentral.com online classes for law exams. So today I will be dealing with you the solved previous year question paper of Haryana Judicial Services examination of the year 2018. This is the latest examination which was held before the examination which is scheduled to be held on 2021, in the year of 2021. So let us see the questions. So today I am going to deal with you a total number of 125 questions. So let us start with the first question. Match the following persons in list 1 with their achievements in list 2. So let us match Rajkumar E. Amrit Kaur. So this is A4's first woman central minister. Leela Seth, she was the first woman high court. Suchita Kriplani was the first woman chief minister, and C.B. Muthamma was the first woman ambassador. Question number 2. Dash won the first Justice Prize from India, who is also named as the living legend of law by the International Bar Association. This is option number B, Falius Nariman, senior advocate. Question number 3. Which one of the following decided to set up a website which will compare the world's constitution by themes online to arm drafters with a better tool for constitution design and writing? So this is option number C, Google. Question number 4. In deciding the question of negligence by professionals, the classical statement of law which has been widely accepted both by professionals generally and by medical practitioners in particular is popularly called as option number C, Boland test, and this test was let out in the famous case of Bolam versus Free and Hospital Management Committee 1957. Question number 5. Which one of the following dispute cannot be raised before the consumer forum? This is option number A, dispute relating to services by a government servant. Question number 6. Law of contract creates jus in personam. Question number 7. Void agreements includes option number D, all of the above. Agreements in restraint of marriage, agreement in restraint of legal proceedings, and agreements with minor given under section 26, 28 and section 11 of the Indian Contract Act. A minor is option number C, liable for necessaries supplied out of property by virtue of section 68 of Indian Contract Act. Question number 9. Which is the first country to allow voting through mobile phones? Is option number A, Estonia. Question number 10. Who said that the people who have a right and inalienable, indisputable, indefeasible, divine right to that most dreaded and envied kind of knowledge, I mean of character and conduct of their ruler? This is option number D, John Adams, and he was the second president of America. 11. Goods are deemed to be in course of transit from the time when they are delivered to a courier or other bailey for the purpose of transmission to the buyer until option number A, until the buyer or his agent in that behalf takes delivery of them from such courier or other bailey given under section 51, which deals with goods in transit. Question number 12. In the case of dash, it was held that lottery tickets are goods and not actionable claims. The sale of lottery tickets is sale of goods. So this has been decided in the case of H. Anraj versus Government of Tamil Nadu 1986 case. Question number 13. A bought a horse from B. A wanted to enter the horse in a race. Turns out the horse were not capable of running a race on account of being lame. But A did not inform B of his intentions. So B will not be responsible for the defects of the horse. So in this case, this option number A, the doctrine of caveat emptor will apply, and B will not be responsible. A will not be responsible for not informing B because of the doctrine of caveat emptor, which means buyers beware, and it has been given under section 16 of the Sales of Goods Act. Then question number 14. Documents of which registration is optional? This option number A, will. So will is actually not a compulsorily registrable instrument. Question number 15. Identify the correct proposition. So you have to choose the correct option. The correct option is option number B. Let us read. A consent decree purporting to create a gift require registration under section 17 clause 1 subclause A and is not exempt from registration under Section 17 Clause 2 of the Registration Act 1908. A gift is mandatorily registrable. Question number 16. The calling of at least one attesting witness to prove a document under Section 68 of the Indian Contract Act is not necessary when option number A, when the document other than a will is registered under the Indian Registration Act 1908. So when the document is registered, then no witness is actually required to call before the court to prove the document. Question number 17. Which statement is true in relation to a child witness? The correct option is option number D. All of the above statements are true. Let us read. A child of tender age can be allowed to testify if he has intellectual capacity to understand questions and give rational answers thereto. This is correct. A child witness may be easy prey of tutorial, and when it is established that he is under the influence of tutoring, it is not safe to solely rely on his evidence. This is also true. The law recognizes a child as a competent witness, but a child of a tender age of 6 years is not considered by the court to be a witness whose sole testimony can be relied without other corroborative evidence. So all these statements are true. Then question number 18. Under section 145 of the Evidence Act, a witness may be contradicted as to previous statement in writing when without proving the same, but only after showing the same to the witness. That's how his statement can be corroborated. Question number 19. The narco-analysis technique involves the intravenous administration of option number A, sodium pentothal. So this is a chemical used for narco-analysis test. Question number 20. The evidence unearthed by the sniffer dogs falls under option number C. This only hearsay evidence. And this has been held in the case of Dinesh Bodh-Thakur versus State of Assam. 21. Under Section 1 Clause 3 of the Haryana Urban Control of Rent and Eviction Act 1973, an exemption for a period of dash from the operation of the Act is allowed to buildings, the construction of which commenced or was completed on or after the date of commencement of the Act. So an exemption for a period of how many years? This is option number B, 10 years. Question number 22. The Muslim Women Protection of Rights on Marriages Ordinance 2018 provides for. So it provides for this option number A, 1 and 4. Let us read. It declares instant triple talaq illegal and criminalizes it. And 4. It entitles Muslim women against whom triple talaq has been declared to seek subsistence allowance from her husband for herself and for her dependent children. Question number 23. A Muslim gift is not compulsorily registrable. This is true. Option number B. 24. If husband swears that he will not have sexual intercourse with his wife for 4 months or more, it amounts to a form of divorce known as option number A, ILA. It's a kind of constructive divorce. Question number 25. Payment and delivery under Sale of Goods Act 1930 is option number C. It's a concurrent condition. And it has been given under section 31 of the Act. 26. A non-testamentary document is one. This is option number D, all of the above, which is intended to take effect or be operative immediately on its execution, then which is final, which is irrevocable. So that kind of instruments are known as non-testamentary document. Question number 27. What is the effect of opinion of the experts upon the court? So this option number D, B and C all advisory in nature. The judge can form an opinion contrary to that of expert given under section 45 of the Evidence Act, which deals with expert opinion. 28. Use of violence by a member of unlawful assembly in furtherance of their common object will constitute the offence of option number B, writing, defined under section 146 of IPC. 29. A is arrested by police and accused of murder B. During investigation, A voluntarily agrees to undergo narco analysis and therein he confesses to have murdered B. So in this case, the correct option is option number D, none of the above. The confession is relevant and can be sole basis of conviction. This is not true. The confession is irrelevant, and then the confession is relevant but requires corroboration. Only that much of A statement can be used as leads to discovery of facts. This actual option number D, by mistakenly I said option number D, this actual option number D. Only that much of A statement can be used as leads to discovery of a fact given under section 27 of Indian Contract Act, and this proposition has been laid down in the case of Selvi versus State of Karnataka. 30. The general rule is that leading questions cannot be asked during examination in chief. However, there are some exceptions to this rule. Choose the exception. This is option number D, both B and C. Let us read. As to matters which are introductory or undisputed, and then as to matters which have already been sufficiently proved, and regarding to these circumstances, leading questions can be asked during the examination in chief, and this has been enumerated under section 143 of Indian Evidence Act, which deals with leading questions. Question number 31, delay in filing the suit. This option number B cannot be condoned, because only application and appeal can be condoned under section 5 of Limitation Act, not suit. Question number 32, section 3 and section 14 of Limitation Act, they are actual option number A, both independent and not mutually exclusive. Question number 33, identify the correct statement. So here the correct statement is option number D, none of the above. All the statements are incorrect. Section 5 is applicable to application and appeals only. Section 10 is applicable to suits against trustees and other representatives. So this statement is regarding section 5, which deals with the condonation of delay, and suits relating to the trust and or representative suits. 35. When can the landlord convert residential building into a non-residential building under section 11 of the Haryana Urban Control of Rent and Eviction Act 1973? This option number B, with the permission of the controller. Question number 36. Secondary evidence of a document is admissible in evidence as a substitute for admissible primary evidence. Question number 37. As per the Evidence Act, admissions are option number B, are not conclusive proof of the matters admitted but operate as estoppel. Question number 38. In criminal trials, the accused has to establish his plea for the mitigation or justification of an offence. This is option number A, substantially. So the accused has to establish substantially his plea for the mitigation or justification of an offence. Question number also known as burden of proof. Question number 39. All statements which the court permits or requires to be made before it by witness in relation to matters of facts under inquiry is or are option number B, they are known as oral evidence. All statements which the court permits. Question number 40. Under section 116 of the Evidence Act, the tenant is stopped from denying. Option number B, the title of the property of the landlord. Only the title of the property of the landlord. Question number 41. Rehabilitation scheme for victim compensation is prepared on the recommendation of dash. This option number C, District Legal Services Authority and State Legal Services Authority. 42. As per the provisions of the CRPC, offences can be compounded under section 320 by the legal guardian of a person who is, the correct option would be option number D, all of the above. So these are under the age of 18 years, who is an idiot, who is lunatic. So for all of these persons, the offence can be compounded by their guardian. Question number 43. As per provisions of section 315 of the CRPC, an accused, option number C, can be called as a witness only on his own request in writing. That's what section 315 says. Question number 44. As per the provisions of section 437 of the CRPC, the jurisdiction to cancel the bail vests with option number C, the magistrate only, where the magistrate has ordered release on bail. Question number 45. As per the provisions of the CRPC, surety can be sentenced to civil imprisonment in default of payment of penalty under the surety bond for a maximum period of, this option number B, 6 months. And this has been given under section 446 of the CRPC, very important section. 46. The test of ascertaining the burden of proof lies on the person who would fail if that part is not proved, is contained in section what? Option number C, 102, which deals with burden of proof. 47. Section 124 of the Evidence Act provides for privilege in respect of option number A, official communications. 48. In execution of a decree for the maintenance, salary of a person can be attached to the extent of, the correct option is option number C, 2/3. and it has been given under section 60 clause IA of the CPC. 49. The commissioner appointed for the purposes of recording evidence cross-examination is obliged to submit its report to the court appointing the commission within option number C within 60 days from the date of issue of the commission, and this has been given under order 18 rule 4 clause 5. Question number 50. Where a mortgagee obtains a decree for payment of money in satisfaction of claim arising under the mortgage, so in that case the correct option is option number B. Let us read. He is entitled to bring the mortgage property to sale only by instituting a suit for sale. So that's how only the mortgage property can be sold. He has to institute, the mortgagee has to institute the suit for sale in enforcement of the mortgage under order 34 rule 14 of CPC. Question number 51. Chapter 21A of CRPC dealing with plea bargaining has been inserted by, so very important question, and this has been inserted by Criminal Law Amendment Act 2006. So here it is actually in the option itself is not given. It's criminal law inserted by Act number 2 2006. This has been actually the nearest option would be option number C, the Code of Criminal Procedure Amendment Act 2001. Question of 52. Section 167 of the CRPC provides that the nature of custody can be altered from judicial custody to police custody and vice versa. This alteration can be done during the period of first, option number A, only for the first of 15 days. Question number 53. The maximum number of offences of the same kind that can be tried together is, so this is actually option number D3, and this has been given under section 219 of CRPC, which says the 3 offences of the same kind within a year may be charged together. 54. As per the provisions of the CRPC amended in 2005, a surety has to declare the number of accused from whom he is surety under section option number B 441A of CRPC, which is a mandatory provision. Question number 55. Evidence shall be taken down by the magistrate either himself or by dictation in open court, which amended provision of the CRPC permits audio, video, electronic means in the presence of advocate of the accused. This is option number B, proviso to section 275 clause 1. It actually provides for audio, video, electronic means in the presence of advocate of the accused, that means in camera trial. Question number 56. Order 6 rule 16. CPC empowers the court at any stage of the pleading to strike out any matter contained in it. Only option number D, all of the above. Let us see if it is unnecessary, scandalous, frivolous or vexatious. If it tends to prejudice, embarrass or delay the fair trial of suit. If it is an abuse of the process of the court. Question number 16. A court may order striking of the pleadings in the following cases. No, not that one. 57. Mark the correct statement. So again, all of the above in set of court fee is payable by the defendant. This is true. The order 8 rule 6 CPC deals with legal set-off. This is also true. Legal set-off can be claimed as of right. The equitable set-off is dependent the court's discretion. This is also true. Equitable set-off is actually a discretion of the court. A legal set-off is a right of the defendant. So these are reason why option number D, all of the above. Question number 58. An agreement entered into a compromise on behalf of a minor without the leave of the court under order 32 rule 7 of the CPC is, this actual option number A, voidable against all the parties other than the minor. Question number 59. On dismissal of the suit for non-compliance with an order for discovery under order 11 rule 21 of CPC, then in that case correct option is option number C. The plaintiff is precluded from bringing any fresh suit on the same cause of action. So then it means that once the matter has been dismissed, the plaintiff cannot bring a fresh suit on the same cause of action. And this has been given under order 11 rule 21. It's already given in the in the question itself. Question number 60. Order 70 rule 2 and order 70 rule 3 of CPC are, they are actually independent and mutually exclusive. This is option number B. Question number 61. A partition of joint family property has to be done. Option number C can be oral or in writing. And this has been held in the case of Peddu Reddivar versus Gothanda Reddy. 62. Under section 173 of the CRPC as amended in 2018, the investigation into the offence of rape shall be completed within a span of option number D 2 months. Question number 63. A person can be arrested without warrant in the case of option number D, all of the above, as preventive or precautionary measure, then for obtaining correct name and address, for securing attendance of accused at trial. So in all the above cases, the accused person can be arrested without warrant. 64. A warrant of arrest is a command and should be option number D, all of the above. It must be in writing, must be signed, sealed and issued by a magistrate, addressed to a police officer, given under section 70, which deals with the requisites of a warrant. Question number 65. Who among the following is not entitled to claim maintenance under section 125 of CRPC? Divorced wife so long as she doesn't marry, then unmarried sister, adoptive mother, illegitimate minor child. So this question has been deleted because this question has been wrong. It's not entitled. So even an unmarried sister is not entitled. Then an adopted mother, adoptive mother is actually entitled. Illegitimate minor child, these also two. Divorced wife as long as, here the correct option would be option number B, unmarried sister. Question number 66. Arrest and detention of a person is civil imprisonment in execution of the decree. This is actually option number C, letter C. Doesn't absolve him, but the person cannot be re-arrested. Question number 67. In cases of withdrawal of suit by the plaintiff under order 23 rule 1A of CPC, in that case option number C, defendants can be transposed as plaintiff if substantial question is to be decided against any of the other defendants. So in the case of withdrawal of suit by the plaintiff, the defendants, the group of defendants which are actually contesting the case, they can be transposed as plaintiff if as any substantial question arises about any amendment, that means what? About any decision of the right. Question number 68. The land for the beneficial enjoyment of which the easementary right exists is called, so they are actually called servant right. They are actually called as dominant heritage. The land for which beneficial enjoyment of which the easementary right exists are called dominant heritage. Question number 69. Under section 34 clause 2 of the CPC 1900, where a decree is silent with respect to the payment of further interest on the principal sum from the date of the decree to the date of the payment on the earlier date. So in that case option number B, the court shall be deemed to have refused such interest. So suppose if a person actually fails to take this to take this plea, that they, or to say if they fails to claim for the interest, then in such a situation the court will refuse to grant such interest, because in the petition itself the plaintiffs have actually failed to raise the issue of interest. Question number 70. During the execution proceedings, if a question arises as to whether any person is a representative of a party, such question shall be determined by this option number A, court which passed the decree. This has been given under section 50 clause 1 of CPC, which deals with legal representatives. Question number 71. A married B and subsequently married C during the lifetime of B. One Mr. D petitions to the court for declaring A's marriage with C as void. Examine the maintainability. This option number A. Only either party to the marriage can get the relief of nullity of the marriage. Not a third person can institute a suit for declaring someone's marriage as null and void. Question number 72. Adoption doesn't deprive the adoptive father or mother of the power to dispose of his or her property by transfer, inter vivos or by will. Which section of the Hindu Adoptions and Maintenance Acts provides for the same? This has been given under option C, section 13 of Hindu Adoption and Maintenance Act. which says that subject to any agreement to the contrary, and adoption doesn't deprive the adoptive father or mother of the power to dispose of his or her property by transfer, inter vivos, or by will. 73. Admits are the heirs of option number B wholly related through males, and the definition has been given under section 3 clause 1 subclause A of Hindu Succession Act. 74. Any property possessed by a female Hindu, whether acquired before or after commencement of the Hindu Succession Act, shall be held by her as option number C as a full owner, and this has been given under section 14 of Hindu Succession Act. 75. Sapinda relationship for the purpose of Hindu Marriage Act includes 3 degrees of the ascent through mother and 5 degrees of ascent through father, and this has been defined under section 3 clause F of the Hindu Marriage Act. Question number 76. Private alienation of property by the judgment debtor after attachment under section 64 clause 1 of CPC is option number C void. 77. Under order 39 rule 2A CPC, a person guilty of disobedience or breach can be penalized by option number C either A or B or both. Question number 78. Under the provision of Civil Procedure Code, plea of adverse possession is a defense available. Option number B only to defendant against plaintiff. Question number 79. Preliminary decree can be passed in a suit, all of the above. So preliminary decree can be passed in a suit for all of the above, for partition, off partition, for possession and men's profit, and this has been given under order 20 and 34 of CPC. Question number 80. Which of the following is not a decree? This is option number A, dismissal in default. 81. A Hindu female propositus died leaving behind a sister, 2 sons, 1 daughter, mother and father. Find the share of the daughter. So here the share of the daughter would be option number B, 1/3. Question number 82. In the debate on the custody, guardianship or adoption of the child, the courts in India is governed by which of the following principles? This is option number A, best interest of the child, and this has been held in the case of Gayatri Bajaj versus Jiten Bhalla. 83. Order of permanent alimony under section 25 of Hindu Marriage Act 1955 can be varied, modified or rescinded. This is actually option number D. All of the above statements are correct. Let us read. If the party in whose favor the order has been passed remarries, then if the party in whose favor the order has been passed, if the wife and she has not remained chaste. Third, if the party in whose favor the order has been passed is the husband and he has had sexual intercourse with any other woman. So in all of the above cases, under section 25, the maintenance can be varied, modified or rescinded. Question number 84. Find out the correct statement from the following. So let us find the correct statement. So here the option is option number B, 2 and 3 are correct. Let us read. A void marriage is never a valid marriage, and there is no necessity of a decree annulling it. This is very true. And then question number 3, the option number 3, a voidable marriage is regarded as a valid subsisting marriage until a decree annulling it has been passed by a competent court. So both of the above statements are true. Question number 85. Under the Hindu law, after passing of a decree for judicial separation, if one of the spouse dies intestate, the other spouse, the correct option is option number A, can inherit the property of the deceased spouse. This is very true. Question number 86. Under dash, redemption of mortgage can be sought by any one of the legal representatives after the death of the mortgager. So, and this has been given under option number A, order 32, rule 1 of CPC. Question number 87. In which of the following reads the doctrine of res judicata is not applicable? This is option number A, habeas corpus. And the case involved is Ghulam Sarwar versus Union of India. 88. If the election of the President of India is declared void by the Supreme Court, the acts performed by the President incumbent before the date of such decision of court are, the correct option is option number C is valid. Question number 89. Which of the following sentence is or are correct? The correct option is option number A, 1, 2 and 3. Let us read. The President can commute death sentence to the life imprisonment. Second, the Governor cannot commute death sentence to the life imprisonment, this is also true. And then third, the president's power to pardon extends to the punishment or sentence by court. So all of the above statements are true, and this power has been conferred on the president under Article 72. Question number 90. In 2017, the Supreme Court held that right to privacy is protected under Article 21 of the Constitution of India in the context of, option number D, Indian biometric identification system. Then the case law is Justice K.S. Puttaswamy versus Union of India. 91. Which of the following statement is true about malice in fact and malice in law? The correct option is option number A. The former is a wrongful act done intentionally without just cause. So malice in law is actually an act and a wrongful act which is done unintentionally. And malice in fact is wrongful act done intentionally with evil motive. So the former is actually done intentionally without evil motive, and the second one, malice in fact, is done intentionally with evil motive. Question number 92. The term pari passu means, it means option number A, equal right of another creditor with that of the secured creditor. Question number 93. In 2016, the Supreme Court has clarified that the third gender will include option number C, transgender. 94. Qui facit per alium facit per se. So this actual option number B, he who acts through another acts himself. So this maxim is applicable in the case of vicarious liability. 95. Who has a right to partition under Hindu law? So this is actually the correct option is it's actually none of the above. Who has a right to partition under Hindu law? Because son conceived at the time of partition is not, doesn't have a right to partition. He can only sought for the partition. He can only seek for the partition after he takes birth, but not before that. So this is the reason why the correct option would be option number D, none of the above. Question number 96. The Constitution of India empowers the Supreme Court of India to adjudicate disputes between the centre and the states through option number B, original jurisdiction given under Article 131. Which of the following is not true about the Attorney General of India? The correct option is option number B, only 3. This is, he has the right, he has the voting right in the proceeding of the parliament. This is not true, and this has been given under Article 76. Question number 98. Which of the following are true about the fundamental duties of Indian citizens? So the correct option is option number B. 1, 2, 3, 4, 5 and 6 are true. So let us read except for 7. They require us to safeguard public property. They require us to protect and improve the natural environment. They are contained in Article 51A of the Constitution of India. They were added by 42nd Amendment of the Constitution of India. They require us to develop the scientific temper and spirit of inquiry. 6. They were originally 11 fundamental duties. So all of the above. Then question number 99, match the following. So let us match. Indira Sahni versus Union of India is a case relating to option number 4, Mandal Commission. Then question number B, option number B, Keshwananda Bharti versus State of Kerala is a case relating to Doctrine of Basic Structure. Aruna Ramchandra Schonberg versus Union of India is a case relating to passive euthanasia. And Selvi versus State of Karnataka is a case regarding to validity of narcoanalysis test. And the last one is Food Corporation of India versus Messrs Kamdhenu Cattlefield. This case is relating to Doctrine of Legitimate Expectation. Question number 100. Doctrine of Legitimate Expectation and Wednesbury Principles were read by Supreme Court into option number B, Article 14. So let us understand what do you mean by Doctrine of Legitimate Expectation. It imposes in essence a duty on the public authorities to act fairly by taking into consideration all the relevant factors bearing a nexus to such legitimate expectation. That means it requires the executive authority to work in a reasonable fashion. Question number 101. If the act is lawful one and not a criminal act, and if in the course of such act any one of the persons jointly doing that act commits an offence, then then in that case option number B, only the doer of the act shall be liable for it and not others, and section 34 of IPC will not be applicable. Question number 102, right to private defense is this option number A available or where there is no time to have recourse to the protection of public authorities. Question number 103, Punjab State Reorganization Act was enacted in the year option number E 1966. Question number 104, a child who doesn't understand or distinguish between the right and the wrong is called as Dolly Incapax. This is defined under which section of IPC? This option number is section 82, which says Dolly Incapax means child below the age of 7 years is not liable for consequences of his act. Question number 105, section 396 of IPC deals with option number B, dacoity and murder. Question number 106, reference by the President of India under Article 143 clause 1 of the Constitution in the case of Keshav Singh's case relates to, it actually relates to option number C, privileges. Question number 107, which of the following statement is true regarding a decree of declaration? So let us see option number A, 1, 2, 3 and 4, that means all are correct. It creates no new rights, then it cannot be prayed as a matter of right, then if all the parties are not joined, declaration cannot be granted. 4, such a decree is conclusive between the parties, twin and persons litigating through them. Question number 108, extended period of limitation for institution of a suit for specific performance of a contract cannot stretch beyond. This is option number C, 3 years from the cessation of the disability. Question number 109, under section 6 of the Specific Relief Act, the suit can be brought by option number C, a tenancy by holding over. 110, by virtue of section 6 of the Specific Relief Act, a suit for possession of an immovable property can be filed within a period of dash of disposition. So it can be filed within a period of 6 months. Option number C. Question number 111, if a partner withdraws from a firm by dissolving it, then it's a dissolution and not retirement of a partner. Question number 102, according to section 44 of the Indian Partnership Act, the court may dissolve firm on the suit of a partner on any of the following grounds. Option number D, all of the above: insanity, permanent incapacity, breach of agreement, and all of the above. 113, the age of consent for sexual intercourse between a husband and wife has been made dash from years by the Supreme Court, has been made 18 years from 15 years. This is option number D, and this has been held. This is a very important case law. The name of the case is Independent Thought versus Union of India. Which one of the following statement is not correct? So let us see the option number C. An order granting permission to withdraw the prosecution solely on the ground that where about of the accused was not available is permissible. Actually, it is not permissible, but in the option says it is permissible, and this has been given under section 321 of the CRPC, which deals with withdrawal from the prosecution. 115, the maximum period of solitary confinement provided under section 73 of IPC is option number C, 3 months. 116, it is mandatory that transfer of an actionable claim can be effected only by the instrument in writing, but it doesn't have effect on option number A, negotiable instrument. Question number 170, which of the following statements are true? The correct option is option number C, 2 and 4. Minor's contract cannot be ratified on attaining majority. This is actually true. And 4, minor is not liable under the minor's contract. So both the statements are true. Question number 118, in case of specific performance of part of contract of purchaser. So the correct option is none of the above. Actually, this question has been deleted because this is actually a wrong question. Question number 119, contract in restraint of trade is, so it is actually option number A, void and given under section 27 of Indian Contract Act. Novation amounts to, so it actually amounts to option number A, discharge of contract. Question number 121, which of the following won the 2018 UNESCO Asia Pacific Award for Cultural Heritage Conservation? This is option number A, Ladakh Restoration Project. So these are the old current affairs questions of the year 2018. Which among the following is not a constitutional body in India? So this is actually option number C. Planning Commission is not a constitutional body. Question number 123. Who authored the award-winning book Fault Lines? How Hidden Fractures Still Threaten the World? This has been written by Raghuram Rajan. So this is a very important book. I suggest you to remember the author of the book and the name of the book. 124. The voting age for elections to House of Peoples and to the Legislative Assemblies was lowered from 21 years to 18 years by this option number A, the Constitution 61st Amendment Act 1988. Question number, and this was done by amending Article 326 of the Constitution. 125. The liability by holding out partner in case of returning partner continues up to the date of option number B, date of public notice about such retirement. Till he gives public notice about such retirement, he shall be liable for the act of the firm, and this has been given under section 32 of the Partnership Act. So these are the questions for today, and I hope you all have liked it. And let me tell you one very important announcement, like the dates have been extended. Like those of you who haven't applied for Haryana Judicial Service exam, they can apply till 16th of September. So if you haven't submitted or haven't filled up your form yet, you can do so by visiting their website hpsc.gov.in. So I hope you all have understood this session, and if you have any doubts, queries, feedback or suggestion, you can write the same in the comment section below. So with this note, I am signing off. Have a great day.